Got it. So that's similar on the patent side, where you have that parent application and you have something close or similar. We say timeout. Let's wait for that examiner to either restrict or to come up with a rejection. Then you can file what's called a child patent. A little different process, but it sounds like you want to basically get that thumbs up first and then sort of green light to file subsequent related.
Exactly. And that's a strategy too that we use for clients who have maybe a somewhat descriptive trademark. Maybe it's not nearly descriptive, but it's borderline. And we're thinking ready to push back. Maybe we file that design trademark first, it registers, and then we cite that trademark registration in our wordmark application afterwards.
I'm a content creator who said some semi-popular phrases, and I want to sell t-shirts with those phrases on them. Should they be trademarked first?
Well, you already come up with the name, the semi-popular phrase, so no, it doesn't need to, right? No, I mean, yes, you can file them before, during, or after you're using the trademarks.
Okay.
So, yeah, they certainly could. Now, like the tricky thing about apparel and trademarks and semi-popular phrases is there's a lot of ways the USPTO can say that that's not actually functioning as a trademark. It's not a source identifier. If it's just a catchphrase, right, it does not necessarily connect that consumer to your apparel product. It's not a trademark. So a couple ways that you need to look at that is one, a trademark is used, in typical traditional trademark place for apparel, which is the upper left breast pocket area, or on the tag itself. Those are the two places the USPTO says that's a trademark. So it can't be in big font letters in the front, right? It's got to be in a specific location on the apparel. And then the second thing is it can't be a common phrase, phrase that's used in common vernacular. And it can't be descriptive, right? And again, it has to function as a trademark. It can't just be an ornamental design. It has to have trademark significance, source identification.
Speaking of semi-popular phrases, Bold Patents has got one. Go big, go bold, for example. I've used that a lot over the years. What do you think? If I were to put that on,
did we register that? We must have registered that, right?
We did.
We got the huge portfolio. Yeah, that's a registrable trademark.
Okay, perfect. But on not related to an apparel. We're not a manufacturer of t-shirts, apparel.
No, I don't see us going into the apparel business.
No. Okay. But I certainly could blazon that, but doesn't give any significant benefit.
Yeah, I mean, if you want to send me like a vest or something with, bold IP on it, I'll throw that on for client calls.
So is it possible to sue for patent infringement? Yes. While patent is under patent pending status. Okay. It's always possible to sue. Enter suit. Allege certain claims.
That's where I always tell clients, you can sue anyone for anything.
You can. So definitely the answer is yes, it's possible. Should you is probably the better question. And the answer is no. Unfortunately, while an application is pending, you have no rights. And it's kind of a heartbreaker to tell clients this, that there's no legal rights until the patent is granted. Now, you do have some sort of pseudo rights, we call them. You've got the ability to put actual infringers, potential infringers on notice.
And what's the benefit of that? Why would you want to put them on notice?
Big benefit. If they decide that after seeing that notice, and you can sort of get one of those read receipts or even a certified mail, right, with a signature confirming their receipt, and they continue to infringe as a willful infringer. And now you can allege and negotiate additional damages, up to treble damages. It's called
treble damages and attorney's fees.
Yes, getting big trouble. And otherwise, it's a good thing to do. The patent office does it for you by publishing your patent application. But it's
constructed notice.
Constructed, yeah. And it's sort of, you'd want to be able to send that to them or really notify. And a lot of times that's done through things like cease and desist letters or a notice letter. And you can do that. So unfortunately, no rights to actually threaten and, assert your allegations in federal court or even at the ITC, the Customs Border Protection. You do have to wait till your patent gets granted.
Same with the trademark side. Exact same.
On trademarks. Okay.
You can't really do any enforcement until you have that registration certificate in hand.
My company has 2 trademark registration in process in the U.S. Both received a non-final office action with both were responded and are waiting for the attorney from the USPTO to decide.
Yep. We
do have a third mark we want to register. The logo is similar to both marks on the process. If we request this third mark to trademark registration, would that hurt the other 2 that are going on right now?
Good question. So this gets at trademark strategy, right? So a lot of times we have clients who are in multiple different classes at the USPTO. maybe one of those classes we think we're going to have a problem with. So, if we think one of the applications might have a likelihood of confusion with a prior file application or registration, maybe we don't want to file that one until the other applications have been reviewed by the USPTO examiner. Because what I don't want to do is stir the pot, have an issue with one application over here, and have that issue impute to the other applications because they're all related. USPTO will do that. This kind of gets at talking to your attorney about the strategy. And in this particular case, I would say if there's any hesitation to file based on likelihood of confusion or descriptiveness issues or whatever, don't file it right away. File the other ones first. Wait until they've been approved by the USPTO. You get that notice of allowance, then file it.
Got it. So that's similar on the patent side, where you have that parent application and you have something close or similar. We say timeout. Let's wait for that examiner to either restrict or to come up with a rejection. Then you can file what's called a child patent. But A little different process, but it sounds like you want to basically get that thumbs up first and then sort of a green light to file subsequent related.
Exactly. And that's a strategy too that we use for clients who have maybe a somewhat descriptive trademark. Maybe it's not nearly descriptive, but it's borderline and we're thinking ready to push back. Maybe we file that design trademark first, it registers, and then we cite that trademark registration in our wordmark application afterwards. I think I will say, like in my 14 years doing this, that's kind of something that, as you get more and more experience, you get more reps under your belt, that strategy becomes more apparent.
Yes. Love it. Is it possible to copyright and patent the same thing at the same time? Really interesting question here. So
might as well
copyright. Yeah, why go for the full triple in park home run and keep it as a trade secret too. So I mean, you can do certainly a filing with the Copyright Office. And I don't claim to be a copyright registration expert. From my understanding of that process with the Library of Congress, it's a separate governing body. There's no examiners at the Copyright Office. Its main purpose is to register and just create an undeniable database of when something was submitted, by who, here is the substance of the work, of the artistic work, whether it's written, visual, sculpture, and that's it. And so it can act as a nice, on its face, evidence of submittal by a alleged author. There's no requirement for novelty, right? It doesn't need to be one of a kind, doesn't need to have certain rules with respect to commerce like trademark does. So I suppose if you've got, a three-dimensional work of art you think might also be worthy of design patent protection, yeah, maybe you could file that sculpture as a piece of artwork with the Copyright Office and file as a design patent with the U.S. Patent Office. And you could secure both. And if you're going to be selling that sculpture, you might as well consider going into business and filing a trademark for your business too, and keeping the methods for how to make that thing as a trade secret. So